So cancelling or getting out of a bad property transaction often creates a bit of confusion amongst property investors and property buyers. Now, the first thing that we need to understand is there is a difference between a contract lapsing and a contract being cancelled. And I think this distinction is paramount in order to be able to have a discussion around the different possibilities of the different options to people buying property to exit property deals. Now, suspensive conditions are typically the conditions, especially for first-time home buyers, included in a contract for the obtaining of finance. Now, obviously, as you develop as a property investor, these suspensive conditions might become more comprehensive, more detailed. You might be looking for rental rolls and a whole range of different things. But usually, for your property buyers, the most common would be obtaining of finance. That means a loan from a bank. So a person makes an offer, but the contract. So if the offer is accepted, there usually is a contract. Now, the thing with suspensive conditions is that it suspends the operation and enforceability of the contract until that condition has been fulfilled. So this is for the benefit usually of the purchaser, and the purchaser now has an opportunity to find money, for example, money from a bank. And if it can't find money from a bank, then basically the contract lapses, the contract falls away, it is no longer enforceable. So in the eyes of the buyer need not go ahead with the contract any longer. Suspensive conditions can come in many, many shapes and forms, and we can have a 2-hour discussion around what these could be. But ultimately, it gives the buyer, usually the buyer, an option to basically exit the deal if something doesn't work in the buyer's favor. Now, this is very different from a breach of a contract by a seller, for example. Because when a seller breaches a contract, the contract does not simply lapse. And there usually are steps that must be taken by a purchaser in order to terminate the effect of the contract. Many contracts, for example, require that a notice be given by the purchaser to the seller, forcing them or giving them the opportunity of rectifying their breach. And only if the seller fails to rectify the breach will the purchaser be able to cancel the contract. Now, what does this normally mean? If you look at contracts, especially regarding the sale of properties, the first thing that you need to remember is that these breaches usually need to be material to the contract. So it wouldn't be trivial things that entitle the purchaser to cancel. It needs to be material. And as most people use an example, the condition of the property is often very material. Now, in these instances, a purchaser might have several options. So the first option is to remain in the contract, claim performance, so claim the transfer of the property, but sue for damages. And you'll usually find that this is the case in situations where the purchaser, number one, maybe the damages aren't that high and the purchaser feels that it is able to acquire compensation from the seller for the damages to the property. And now I'm speaking specifically to damages, but this applies to many different examples. So for example, if you buy the property and there's certain damage to the property that you did not know when you buy it, you can continue with the contract but sue for damages. Another example of an option that a purchaser has is to cancel the contract and say, I am not going ahead with it. The item that I'm buying isn't the item that I believe that I was buying, and I'm walking away from this. But, and this is the big qualification, the but, it depends on what is in the contract. So my advice that I just gave you now is very generic because most contracts actually have what we call a voetstoots clause as an example. So if we're speaking about condition of the property, one has to now look at the voetstoots clause and see if there's a voetstoots clause that allows the property to be sold as is. And so the reason I gave this example is just to try and give the viewers an understanding of the steps that need to be taken when a contract lapses versus when a contract has to be cancelled. Unfortunately, each event of breach might be a result of something different that has to be dealt with differently. There might be a clause in the contract that caters or protects the seller from the purchaser being able to cancel in the event of that particular breach, like a voetstoots clause as an example. So one would have to look at the contract. But yes, if the seller is in breach and nothing in the contract protects the seller, then the purchaser should be entitled to cancel. Another thing quickly to remember is that usually if the seller intentionally does something wrong or omits information knowingly, even if the contract protects the seller, more often than not, because that's fraudulent or misrepresentation, the purchaser would actually be entitled to cancel the contract. And the clause that protects the seller wouldn't actually protect the seller in those instances.